Hello friends, in the series on the income tax cases, today we will discuss the case of Mahalasa Exports versus Income Tax Officer. This case has been reported in 105 ITR Tribunal Short Note 69 and the matter has been decided by Bangalore ITAT A bench and the date of the judgment is 17th July 2023. This case is regarding assessment year 2018-19. In this case, there were two very important issues before the ITAT. The first issue was that when the assessee has filed the claim of the duty drawback in the custom department, the procedure is like that. First of all, the assessee files its claim. Then the department verifies the documents and take the decision whether the refund is due to the assessee or not. And if it is due, then the department approves the claim. And whatever the amount is claimed as duty drawback, this amount is taxable under the Income Tax Act. As far as this position is concerned, there was no doubt. But the dispute was regarding the year in which this amount is taxable. The question was that whether in the year in which the assessee has filed the claim of the duty drawback, in that year it will be taxable, or in the year in which the claim will be approved by the custom department, it will be taxable. The assessee has filed the claim in the year 2018, but it was approved by the custom department in 2019. The learned assessing officer was saying that it is taxable in 2018, and according to the assessee, because the assessee was following the mercantile system of accounting, it should be taxed in 2019. AO made the addition, CIT appeal upheld the order of the assessing officer, so the matter was before the ITAT. The ITAT said that the assessee is following the mercantile system of accounting. The right to receive the duty drawback accrues only to the assessee when it is approved by the custom department. So there is no doubt that the amount should be taxable in the year in which it is approved and not in the year when the assessee has made for the assessee has applied for the refund. So this issue was settled in favor of the assessee. Now, in customs, there is rule 17, which says that if any amount has been erroneously given to the assessee as a refund, or if the excess refund has been claimed by the assessee, then in that case, the assessee has to refund that amount to the department with interest. So, in this case also, there was some interest which has been paid by the assessee to the custom department on the excess amount refunded to the assessee, and the assessee has claimed that refund under section the assessee has claimed that interest under section 37 subsection 1 as an expenditure which the assessing officer disallowed by saying that this is penal in nature, it is a fine, so it should not be allowed to the assessee. But when this matter came to the ITAT said that this interest cannot be said into the nature of fine or in penal nature, and it should be allowed to the assessee under section 37 subsection 1, because even the custom rules allows for the repayment of the excess amount claimed by the assessee as refund to the department, and there is interest provision. So depending upon the facts and circumstances and depending upon the nature of this interest, it cannot be said that it is penal in nature or it has any character of any fine, so it should be allowed to the assessee under section 37 subsection 1. At the end of this video, once again I am repeating the name of the case. The name of the case is Mahalasa Exports versus Income Tax Officer, and this case has been reported in 105 ITR Tribunal Short Note 69. The matter has been decided by Bangalore ITAT A bench and the date of the judgment is 17th July 2023. Friends, at the end of this video, I want to say that before relying on this video, please go through the whole judgment, because even a single fact, even a single circumstance can change the whole concept, can change the whole ruling, can change the whole ratio of the judgment. So please read the judgment so that you can apply the facts and law in your case properly. Thank you, friends.